Welcome to this deep dive. We're aiming this session specifically at helping you get to grips with the sometimes tricky concepts of the beneficiary principle and non-charitable purpose trusts.
That's right. And just to be clear up front, the material we're discussing is drawn from documents the University of London makes available to students. We're using it purely for educational purposes today.
Absolutely. So our mission is to really unpack these ideas, why trust law generally doesn't like trusts just for purposes, what the exceptions look like, and some of the key cases you'll need to know.
Exactly. We want to give you a clear understanding, and we'll be highlighting those crucial case names and concepts, maybe repeating them a bit, just to help embed them for your studies and ultimately your exams.
Okay, great. Let's get right to it then. Why is there this general objection? Why can't I just set up a trust, say, for promoting better understanding between nations without naming specific people?
Well, one of the biggest hurdles is what we call the uncertainty of objects. If the trust is just for a purpose, however laudable, like your example, it's often impossible to say precisely who is supposed to benefit.
You mean who has the actual right to get something from the trust?
Exactly. Who can the court identify as a beneficiary? This was a core issue in Reaster's ST, that's Reaster Settlement Trust from 1952.
Okay, Reaster.
And even more fundamentally, you have to look back at Morris v. Bishop of Durham, an older case from 1804.
Morris v. Bishop of Durham.
Yes. Both cases really hammer home this point. If there aren't identifiable beneficiaries, the trust structure typically fails because it's too uncertain. You need that certainty of objects.
Right, so if you don't know who benefits, you run into problems.
Yeah.
What else? I seem to recall something about trusts not being allowed to go on forever.
Yes, you're thinking about the rule against perpetuities. That's the second major objection.
Hmm.
The law generally prevents settlers from tying up assets indefinitely, controlling things from beyond the grave, so to speak.
And purpose trusts could potentially do that.
They could, theoretically. If a trust is for a purpose that doesn't have a natural end date, it might offend the perpetuity rules. There is a case, Macaulay v. O'Donnell, which touches on this concern about trusts lasting too long.
But hang on, aren't there some situations where purpose-like things are allowed, time-wise?
There are, but they're quite specific. You might have a case like Musset v. Bingle, where a trust to build a specific monument was okay that has a natural endpoint once the monument is built.
Okay, like a one-off project.
Sort of, or Ree Lipinski's will trusts, which involved a gift to an association for a particular building project. But again, these tend to involve defined tasks or benefit identifiable groups within the perpetuity period. They don't really negate the general rule against purposes lasting forever.
Okay, so we've got uncertainty of who benefits and the risk of lasting too long. But the real core issue, the heart of the beneficiary principle, is about enforcement, isn't it?
Absolutely, that's the fundamental point. For a trust to work, there needs to be someone who can hold the trustee to account, someone who can go to court and say, hey, you're not doing what you're supposed to do with this property.
Beneficiary.
The beneficiary, exactly. Without beneficiaries, who enforces the trust? This is the central theme in so many of the key cases. We mentioned Reaster already.
Right.
But also think about Ree Shaw, the case involving George Bernard Shaw's Alphabet Trust.
Ah, yes, the 40-letter alphabet.
That one. And Re Endicott is crucial here, too. Very important case, Re Endicott. And also Leahy v. AG for New South Wales. All these cases, in different ways, point back to this need for an enforcer, which usually means a beneficiary. You really need to know these cases. Re Astor, Re Shaw, Re Endicott, Leahy.
Okay.
Yeah.
Okay, Astor, Shaw, Endicott, Leahy. But then we have Reed Denley. That one seems to muddy the waters a bit, doesn't it? The idea that
Yeah.
people who just factually benefit might be able to enforce it.
It does, yes. Denley's trust deed is a very interesting and much debated case. The trust was for land to be used as a sports ground, primarily for the employees of a particular company.
So, not quite beneficiaries in the traditional property owning sense.
Not quite, but Justice Goff argued that because the employees derived a direct, tangible benefit from the purpose using the sports ground, they had sufficient interest or standing to bring the trustees before the court if needed.
So, factual benefit equals standing to enforce.
That was the reasoning in Denley. It suggested a potential way around the strict beneficiary principle for some purpose trusts, provided there's an ascertainable class of individuals benefiting directly.
But how does that square with Ray Endicott? Didn't the Court of Appeal there insist on a more traditional, equitable interest?
That's the tension, precisely. Endicott took a much stricter line, emphasizing the need for beneficiaries with actual equitable rights in the trust property, not just a factual benefit. Reconciling Red Denley and Re-Endicott is, frankly, difficult.
Yeah, the source material points that out, mentioning academic debate. So
Yeah.
that's definitely something you need to be aware of for exams, this Denley versus Endicott conflict.
Absolutely. Understanding that distinction, factual benefit in Denley, requirement for equitable rights in Endicott is key.
There was also a mention briefly of something called excessive testamentary delegation. Is that a major argument against purpose trusts?
It's sometimes raised, but it's generally seen as a less powerful objection compared to the beneficiary principle or perpetuity rules.
What's the idea behind it?
The argument is basically that if you set up a trust for a really vague purpose, you're essentially leaving it to the trustees to decide how your property is used rather than properly directing it yourself in your will. It's like you haven't fully exercised your will-making power.
I see. But it seems secondary to the main enforcement issue.
It often is, yes. The core problem remains who ensures the purpose is carried out.
So let's solidify this beneficiary principle then. It's fundamentally about enforceability.
Exactly. And that quote from Sir William Grant in Morris v. Bishop of Durham really captures it perfectly. He said something like, "There can be no trust over the exercise of which this court will not assume a control.
Right. The court needs control.
For an uncontrollable power of disposition would be ownership and not trust. There must be somebody in whose favor the court can decree performance." It's a fantastic quote to remember because it sums up the whole issue. You need someone for whom the court can order the trust to be performed.
That quote from Morris v. Bishop of Durham, definitely one to note down. Now, the materials also talk about a rights principle versus an enforcer principle. Can you break that down?
Sure, the rights principle is the traditional view we've mostly been discussing.
Ah.
You need beneficiaries who hold actual equitable rights against the trustee. No rights, no trust. Purpose trusts often fail this test because the purpose itself doesn't hold rights.
Okay, that's clear. So what's the enforcer principle then?
The enforcer idea is more theoretical in English law, though it's been implemented elsewhere. It suggests maybe you could have a valid purpose trust if you appoint someone specifically to enforce that purpose, even if they don't personally benefit.
Like a trust watchdog.
Kinda, yes. But then you hit problems. Why should the state get involved in enforcing purely private purposes? And what compels this private enforcer to actually do their job? They don't have a personal stake like a beneficiary does. It's not a binding duty in the same way.
And that's where places like the Cayman Islands come in. They have legislation for this.
Exactly. Jurisdictions like the Caymans, Guernsey, Jersey, they've passed specific laws allowing non-charitable purpose trusts with designated enforcers, creating a statutory framework to overcome the traditional objections. English law hasn't gone down that route generally.
Interesting. Okay, what about a different approach? Instead of a trust for a purpose, what if you give the trustee a power to carry out a purpose?
Now that's a valid distinction and a crucial one. A power is different from a trust obligation.
How so?
A trust imposes a mandatory duty, the trustee must do it. A power, on the other hand, grants discretion. The trustee may carry out the purpose, but doesn't have to.
And because there's no obligation.
The strict need for a beneficiary to enforce that specific obligation doesn't arise in the same way. If the trustee misuses the power or acts improperly, the people who would inherit the property if the power wasn't used, the objects in default, can potentially step in.
But the courts won't just say an invalid purpose trust is actually a valid power, will they?
No, they're generally reluctant to do that. Shaw is a good example where the court refused to reinterpret the failed alphabet trust as a mere power. You intended a trust, it failed as a trust. Tough luck, basically. A trust is a trust, a power is a power.
Got it. Another distinction the material brings up is trusts for persons limited by a purpose. The example used is Reese Anderson's trust. How did that fit in?
Right. This looks like a purpose trust on the surface, say, income to be used for the maintenance and education of my son.
Seems purpose-like.
It does, but the law generally interprets these as trusts for the person, in this case, the son. The purpose, maintenance, and education just defines the way the son is intended to benefit or the extent of his benefit.
So the son is the actual beneficiary.
Yes. He has the right to benefit, and the purpose clause clarifies how. It's fundamentally a trust for an individual, not an abstract purpose lacking a beneficiary.
How do you tell that apart from just giving a gift and saying why you're giving it, like £1,000 to Jane to help with her studies?
That can be tricky, distinguishing a Reese Anderson type trust from a gift with just a stated motive. In the gift with motive scenario, Jane probably gets the £1,000 outright and can spend it on anything.
Okay.
But in a true Reese-Anderson trust, if the purpose is fulfilled, say education is complete and there's money left over, that surplus might not belong to the son, absolutely. It might go back to the settler's estate or to whoever gets the residue of the estate.
I see. So the purpose acts as a kind of limit or measure on the benefit.
Exactly. Cases involving public subscriptions like Re Abbott and Re Andrew, and also Re Asoba, explore this line between a purpose defining the benefit and a motive for an outright gift. It's a nuanced area you'll want to review carefully.
Definitely. Okay, let's move to the exceptions. The famous or perhaps infamous anomalous exceptions where non-charitable purpose trusts are allowed.
Yes, the trusts of imperfect obligation, as they're sometimes called. And the first thing to stress, as cases like Re Endicott make very clear, is that these categories are closed. They are anomalies, concessions to history perhaps, and courts will not create new ones. Reaster also supports this restrictive view.
Don't extend them by analogy. So what are the specific categories we need to remember?
There are basically three core, well-established ones you need to know for your exams. First, trusts for the erection or maintenance of tombs and specific monuments.
Okay, tombs and monuments, like in Re Dean.
Re Dean is often cited, yes. But remember, it has to be reasonable. Re Endicott struck down a trust for some useful memorial to myself as being too vague and not fitting the narrow exception.
All right, specific monuments. What's the second?
Second, trusts for the care of specific animals. Again, Re Dean is relevant here. It involved horses and hounds. So a trust for my favorite cat Tittles might be valid. Not for animals generally, but specific ones.
Okay, specific animals. And the third?
Third, trusts for the saying of private masses, at least to the extent they aren't charitable. This was confirmed in cases like Bourne v. Keene and, more recently, Re Hetherington.
So the three are tombs, monuments, specific animals, and private masses. Those are the ones to memorize.
Those are the core recognized anomalous exceptions. Absolutely commit those to memory, along with the idea that they are strictly limited.
What about that fox hunting case, Ree Thompson? Does that fit in?
Ree Thompson is often mentioned, but it's problematic. It did uphold a trust promoting fox hunting, but, well, fox hunting itself has since been banned in the UK, which obviously affects its relevance.
What?
And arguably, the validity of the trust structure wasn't strongly challenged in that case anyway. So it's best not to rely on Ree Thompson as a solid example of an exception today. Stick to the main three.
Okay. If these trusts don't have beneficiaries to enforce them, how are they supervised? You mentioned trusts of imperfect obligation.
That's where something called the Pettingill order comes in, named after the case Pettingill v. Pettingill.
Pettingill order. Okay.
Since there's no beneficiary owed a direct duty, the trustee usually gives an undertaking to the court a promise to carry out the purpose, like looking after the specific animal.
And the court accepts this promise.
Yes, and then the court can issue a Pettingill order. This order typically gives the people who would inherit the trust property if the purpose trust failed, the residuary legatees or beneficiaries, the liberty to apply to the court if the trustee messes up or doesn't use the funds for the stated purpose.
So it creates a sort of indirect enforcement mechanism.
Exactly. It's not perfect, hence imperfect obligation, but it provides some check on the trustee. So remember Pettingill order in the context of these anomalous exceptions.
Right. Okay, finally, let's just quickly revisit Red Denley. We mentioned the controversy. How has it been treated since? Is it seen as a true exception?
Well, as we touched upon, later cases have often tried to narrow its scope or explain it in ways that fit more comfortably with traditional trust law.
How so?
For example, some courts, like in Re Grant's will trusts, have suggested that a Red Denley-type situation might be better analyzed simply as a discretionary trust for the benefit of the individuals involved.
So just a trust for people, after all.
Or, as suggested in Relipinski, perhaps it's a trust for the individuals, but with a non-binding direction or motive attached regarding the purpose, like the sports ground. The tendency has often been to try and fit it back into the trust for persons box rather than accepting it as a standalone purpose trust exception.
Has it been followed recently, though?
It was applied relatively recently in Gibbons v. Smith in the context of land held for an unincorporated association, suggesting the principle isn't dead. But even if Red Denley applies, you still likely need certainty about the class of individuals who benefit. The McPhail v. Dalton test for certainty would probably still be relevant.
Okay. And you'd contrast Red Denley with cases where a trust for a large group failed.
Absolutely. You have to contrast it with something like RV District Auditor, Ex parte West Yorkshire MCC. There, a trust supposedly for the benefit of all the inhabitants of West Yorkshire, millions of people, was struck down.
Aye.
It failed partly because the class of beneficiaries was considered administratively unworkable and uncertain, but also because the court saw it as an attempt to create a non-charitable purpose trust for the benefit of the area, which fell foul of the beneficiary principle.
Uh-huh.
It shows the limits, even if you consider it Denley.
Okay, this has been incredibly helpful in breaking down a complex area. So for our listeners hitting the books for exams, what are the absolute must-know takeaways?
Right, key things to focus on. Understand that core tension, the law insists on the beneficiary principle for enforceability. Morris v. Bishop of Durham is your starting point, but courts sometimes want to uphold a settler's intentions.
Know the main objections: uncertainty of objects, perpetuity issues, and lack of enforcement, the beneficiary principle itself.
Definitely. Know the key cases demonstrating the strict view. Re-Astor, Re-Shaw, Re-Endicott. You need to be able to cite these.
And understand Reed Denley, the potential factual benefit exception, but also know how it's been interpreted and limited since, and the uncertainty issues related to it. McPhail, contrast with West Yorkshire.
Precisely. And don't forget the anomalous exceptions know the three categories: tombs, animals, masses, and that they are strictly contained, re-Dean, re-Endicott. Remember the Pettingill order for their enforcement.
Understand the why behind it all: enforcement, certainty, perpetuity, and definitely work through those sample exam questions in the Uni of London materials.
Yes, practice applying the principles to fact patterns. That's crucial.
So the big picture is, the beneficiary principle is king in non-charitable trusts, requiring human beneficiaries, though there are these few, very specific historical exceptions, and the ongoing debate around Red Denley.
That's a good summary. And perhaps a final thought for you to ponder as you continue studying, drawing from the reflection point in the materials. Should the law be reformed? Is the current position too restrictive? Think about the arguments for and against allowing more private purpose trusts, perhaps with dedicated enforcers, like in some other jurisdictions. What would be the advantages? What are the risks or policy downsides if we moved away from requiring beneficiaries who have a direct stake and equitable interest in enforcing the trust?
Interesting questions. Definitely something to mull over. Well, we hope this deep dive has provided a solid framework for your understanding of this area. Keep digging into those case details and principles.
And remember, the University of London resources are there to support you. This session was intended for educational purposes, and thorough, independent study is always the key.